Hi, this is Dan Smith of DPS Legal Counsel. Today I want to talk about trademark licensing for your business. A trademark license is essentially giving another party the right to use, under certain circumstances, your trademark. There was a recent case that just came out in the last few days from the 11th Circuit Court of Appeals dealing with some issues surrounding trademark licensing. What this case involved was a man and a woman who had originally been married for a number of years, approximately 20 years, and who had run a family business together during their marriage called Lawn Managers. And this was in the St. Louis area. Now, in 2012, the couple divorced, and as part of their divorce, there was a marital dissolution agreement, or basically a divorce agreement, pursuant to which the wife transferred her 50% ownership of the business to the husband, but the husband granted to the wife, or the ex-wife, the right to use the trademark Lawn Managers for a period of time. And essentially what happened was the husband, who now owned the business totally and owned the trademark totally, licensed the use of the trademark Lawn Managers for a period of time, a number of years, to the wife, and they both operated essentially similar or almost equivalent types of businesses in the St. Louis area under the same name. And so there's a lot of detail in the case, but essentially what happened was, at the conclusion of the period of time during which the wife had the rights to use the trademark pursuant to this license agreement that was in the divorce decree, after that period of time, she apparently continued to use the trademark, and the husband he filed for trademark registration with the U.S. Patent and Trademark Office. He sent a letter demanding that the wife cease using the trademark. She did not cease to use the trademark, and so the former husband sued his former wife for trademark infringement, based on the theory that her trademark license had terminated, that the period of time during which it was to run had run out, and she had failed to cease to use the trademark. In other words, by continuing to use the trademark under the trademark license after it had terminated, she was guilty of trademark infringement. Well, case went to trial, and then it went up on appeal. Essentially, the issue was whether or not what the husband had done when he granted the right to the wife to use the trademark, whether it amounted to what is called a naked trademark license. In simple terms, a trademark license that is considered a naked trademark license is one in which the trademark owner does not control the quality of goods or services that are being sold under the trademark, which is part of the license. Trademarks, the reason behind trademarks essentially is to provide consumers with information about the source of goods and services, so that when you drive down the street, if you see a Starbucks sign, you know what the quality of services are because you know the source of the goods and services that you would find in a Starbucks. The same thing with a McDonald's. If you see the golden arches, you know that's a McDonald's. You know the source of the goods or services, and you expect a certain quality of goods or services. So a trademark puts the public and potential customers on notice as to the source of the goods and services being sold. And so if a trademark owner doesn't control the quality of goods and services that are being sold pursuant to a trademark license by another party under the trademark license, that is called a naked trademark license. And if a licensee can prove that the trademark license is a naked license in which the trademark owner doesn't police the quality of goods and services, the licensee can claim, and in a trademark infringement case, can claim that the trademark owner has abandoned its trademark. And if it's successful on that claim, the trademark essentially is treated as abandoned. The trademark owner loses all rights in the trademark, and so the party that has been claimed to be an infringer is no longer an infringer because the trademark has ceased to have any validity. And so that's what the wife did, or the former wife did in this case. She said, you know, the husband, former husband, did not control the quality of goods and services that I was providing under the trademark license by using the name Lawn Managers. And by not controlling the quality of goods or services, it was a naked trademark license, and my former husband has lost all trademark rights to Lawn Managers, and so I am not in violation of the trademark license. I am not guilty of trademark infringement. Well, the court looked at the whole issue of trademark licensing and whether or not the trademark license that was in the marital dissolution agreement was a naked trademark license. Did the husband or former husband control the goods or services sold by the wife? Now, they looked at whether there was language in the contract itself or the license itself, which was in the marital dissolution agreement, whether it gave the husband contractual rights to control the goods or services. Found that it did not. That's negative. It's a negative thing, and it does tend to make a trademark license look like a naked trademark license because there is no contractual rights to control the goods and services. So that was a negative for the husband. There was no language in the contract itself giving him the rights to control the quality of goods and services. Then it also would look to see whether the husband actually did do something to control the quality of goods and services. In this case, the court could not find that the husband had done anything to actually control the goods, quality of goods and services sold by his former wife. That's another negative. So finally, last possibility for the husband to avoid having the trademark license being treated as a naked trademark license was whether or not, because of a special relationship he had with his former wife, whether he could reasonably rely upon her to provide good quality of services, the same quality of services that he provided under the trademark license for his company. And the court determined that because of the long period of business that the husband and wife had done together before their divorce, because of the fact that there were some of the same workers who had worked for the husband who were now working for the wife doing essentially the same work, and some other things that were some other facts in the case, that it was reasonable for the husband to assume or rely upon the fact that his former wife would provide the same quality of goods and services that he provided in his company. And so the court found, because of that, that there was not a naked trademark license, and so the husband did retain his trademark rights, and the court did find or upheld the lower court's determination that the wife was guilty of trademark infringement. So there were damages and attorney's fees awarded to the husband because of the trademark infringement. What you can take from this case is this: if you do license a trademark in your business, make sure that in your trademark license agreement you provide contractual language that gives you, the trademark owner, the right to control the quality of goods and services provided by your licensee. Because if you don't, you're subject to the licensee later refusing to give up the rights to the trademark, to continue using it at the end of the trademark license and claiming that there was a naked trademark license because you failed to retain the rights contractually to control the quality of goods and services. Because in most cases, you're not going to have the situation with a former husband and a former wife and long-term business operations by them during their marriage to rely upon to find some facts that would avoid a finding of a naked trademark license. So in a normal arm's length third-party kind of trademark license, if you don't have contractual language in the trademark license itself granting the trademark owner the right to control the quality of goods and services, it's going to be a problem for the trademark owner. It could very well end up with the trademark owner losing his rights to the trademark because the trademark license would be considered a naked assignment. So always, if you do a trademark license, make sure you retain the right in your contract to control the quality of goods and services by the licensee. And also you want to actually take steps to make sure during the course of the trademark license that you are checking and inspecting and making sure that the quality of goods and services are up to standard. Okay, I hope that helps. If you have any questions, please feel free to reach out to me, Dan Smith at DPS Legal Counsel.